Hello, all. Welcome to the next session of the new course titled Legal Essentials for Human Resource Management. Now, this is a course that aims to build legal acumen among all people who are indulged in managing human resource so that they can handle their HR functions in a more compliant manner. If you remember our discussion in the last session, we were looking at how the Constitution of India, which is the fundamental building block on which the entire legal legislation of the country is built. We have looked at how that Constitution has influenced various legal provisions and how a lot of labor law derives its power from various articles and subsections of constitution. We had also looked at how judiciary has interpreted various articles of Indian constitution and have extended its scope to much more larger avenues or much more broader avenues of employment. Now, with that background about the structure and key provisions in the constitution, let's have a quick look into historical evolution of labor laws over the years. By this session, you will be having a fair understanding of how various labor laws have been evolving from the colonial age to modern day, and how its fundamental nature have changed and how its objectives have changed to accommodate changing workforce demand and styles. So let's get into this session on historical evolution of labor laws. As you know, my name is Dr. Amish Samalobana. Now, to give you a brief overview, the first labor law was the Factories Act of 1880, first ever labor law. And the purpose of this act was to regulate working conditions in the textile mills. Now, this act, for the first time, brought in certain provisions such as 8-hour working day. Now, restrictions on child labor was for the first time discussed in this act. Restrictions on night work for women and overtime wages for work beyond 8 hours. Now, you might think that, wow, this is such a wonderful piece of legislation that is bringing in so much welfare effect. But if you look at the true motive of why this act wasn't brought in, it was a move towards standardization and perfectionism. So if you look at Indian workforce, they were agrarian in nature. They were not used to a factory style of working. Because of that, there was no concept of fixed work day. There was no concept of reporting on time because agrarian work style is more laissez-faire, uh, more to the context in which the operation is happening. If it is a rainy season, probably you invest lesser work hours. If it is a time when there is so many activities to be done, a farmer might work much beyond than a normal 8-hour schedule. So Indian workers were coming from that background and they were finding it little difficult to adjust to the factory style of working. Hence, a Factories Act was brought in. And it will not be a overstatement if we say that most of the early laws that was brought in during British era wasn't brought in to protect worker rights but its objective was more towards protecting British economic interest. Now let's look at some of the key legislation that has happened in the early 20th century. One of the first among them was Workmen's Compensation Act of 1923. Now, for the first time, this act mandated compensation for workers who were injured in industrial accidents. So, until then, you didn't know if there was an industrial accident, who's responsible. For the first time, we had a piece of legislation which ensured a bare minimum social security, which is if you are injured in a industrial accident, there would be a mandatory compensation. Then came in Trade Unions Act of 1923. Now this for the first time granted legal recognition to the trade unions and protected the rights to form unions for collective bargaining. Now, again, you might think, "Yo, this is such a great piece of legislation, letting workers unionized." But the truth is that ever since World War or even before that, the wave of unionism among workers was getting a strength. So, by this act, by recognizing trade unions legally and giving them a little bit of protection, the British government ensured that suddenly the unionizing of workers will not take a rebellious force, even though later you would have seen a lot of strikes and protests. But trade union acts essentially gave them a legal recognition, and then there were some checks and balances. Trade Disputes Act, another act that came in 1929. Now, this was the time when there was a lot of strikes and lockouts that happened, and this act imposed restraints on strikes and lockout. The simple solution for all the strikes. Now, strikes is when workers are not working. Lockout is when the employer has to close down his enterprise. Now, Trade Dispute Act brought in restraint to both. You might think a Trade Dispute Act would be talking about various mechanisms of resolving disputes. No, the single shot method of dispute resolution was restraints on strikes and lockout. So this was more or less the nature of labor legislations in early 20th century. Another important event was Royal Commission on Labor. Now, this Royal Commission on Labor was appointed by the British government amid an economic depression and Indian nationalist pressure. Now, all the labor laws that was coming in, they were over and over more to protect British economic interest, and there was this entire narrative that labor laws of the country doesn't intend to protect right of the workers. Hence, to study all this issue, a Royal Commission on Labor was set up. Indian trade unions had rejected it, but still they have submitted the report by 1930. Some of the key recommendations of them was to have a Payment of Wage Act, which will ensure timely wage payment and prevent unlawful wage reduction. Now, the commission identified that this is a big problem, so suggested having an act. And they also amended the Trade Dispute Act. There was a Trade Dispute Act which essentially had restrictions on strikes and lockout. After this commission, a new reconciliation mechanisms were brought into picture. Now, post independence, that is, let's say this era was like from around 1947 to 1960, was when a foundation of Indian labor laws were set in actuality. So what has happened is that Indian constitution has been formed, and the constitution had put forward a lot of policies and principles and suddenly the entire law of the country had to be pointing towards the policies and objectives the constitution is putting forward, which of course is towards equality, justice, fraternity, and all those foundational principles of Indian constitution. So suddenly you see a lot of either amendments happening in existing law or new laws which intended to save the fundamental rights of people, or was towards the principles discussed or put forward by the constitution. So some of the noteworthy piece of law were first, of course, Industrial Dispute Act. Now the 1929 Act, if you remember, was a very nothing was there to amicably resolve the dispute. I say the Trade Dispute Act. Now we have a new Industrial Dispute Act which spoke about comprehensive mechanisms for resolving industrial dispute. It said that there would be worker committees, conciliation officers would be there, tribunals would be there. Suddenly we have defined what is a lawful strikes, a lockout. So all those foundations of India's industrial relations system was put in this Industrial Dispute Act 1947. Another act is Factories Act of 1948. So there was original Factory Act I discussed, the first ever act. Now this act consolidated and updated all the factory safety and well-being related provisions. Now it set some standards for occupational health. It spoke about limiting working hours, which is 48 hours a week, not more than that. It mandated there would be a periodic rest. After every 6 days, one day has to be holiday. And it prohibited, of course, the employment of children under 14 in factories. Now, Industrial Dispute Act and Factories Act are two cornerstone legislation that have kind of drived how the entire labor law discussions have happened after this. So there was also Minimum Wages Act. The Minimum Wages Act, again driving it from the constitutional principle of minimum wages. So this act mandated a minimum wage level for workers in certain scheduled, which means that it has to be paid in according to which industry, which state they belong to, or there would be changes according to that, so that there will not be any any exploitation that will happen. That's the whole point of this act. Some of the other interesting or rather noteworthy law would be Employee State Insurance Act, which introduced the concept of social insurance scheme for workers and medical care, maternity care, etc. 1951, there was a Plantation Labor Act which provided for welfare measures for the plantation workers, a group of people who were most exploited during colonial times. 1952, we had a Employees Provident Funds Act. For the first time, we introduced a contributory saving scheme for industrial workers. Now, as things went on, there are a lot of social security laws like Provident Fund Act. We had ESI, Plantation Workers Act, Factories Act, IDA. In and around 1966, there was a first National Commission on Labor. Now, what was the mandate? Their mandate was to study conditions of labor, both organized and unorganized, and to examine if the existing law needs any improvement or any reforms since the times have changed. So that was their mandate. So it came in around 1960, 66, sorry, in 1966 under the chairmanship of Justice P.B. Gajendra Gadka. And there were some key recommendations that was given by this first National Commission on Labor. For example, they spoke about joint committees of workers and management. So they said that in every industrial establishment, with a, of course, if there is a recognized union, there should be a joint committee where members are also present, members from management, I mean members or rather workers are also present, and members from the management are also present, and together they'll come to resolve the matters at that level itself so that it doesn't escalate into bigger problems. They also reviewed wages, social security, housing provisions, training requirements, and a lot of issues. I mean, it was like a very detailed, voluminous report. But the sad thing was that a lot of the recommendations of first NCL or National Commission on Labour was not implemented immediately. A reason being India was going through a lot of political and economic constraints at that period of time. So, a lot of overarching reforms and recommendations that was given by first National Commission on Labour could not be materialized. But being said that, this report, their findings, their recommendations have influenced a lot of subsequent policies which came later. Now, as the time progressed, some incremental amendments, of course, happened. Some new laws kept coming in. There were a lot of judicial interventions also, where Supreme Court played a key role in expanding labor rights. Some of the noteworthy cases being Olga Tellis versus Mumbai Municipal Corporation, where the municipal corporation evacuated roadside sellers, and the court interfered and said that right to livelihood is a fundamental right of everybody. So you cannot just take off anybody's livelihood like that, because right to livelihood is critical to right to life. Another being the popular Vishaga versus State of Rajasthan case, where the court gave in Vishaga guidelines, which became the POSH, Prevention of Sexual Harassment Act later. So at one end there was legislative mechanism that was reinventing and introducing newer legislation, and there were judicial intervention that was happening, which have led to a broader interpretation and expansion of labor rights. As the things went on, in and around 1990, there was this economic liberalization that has happened. And once it has happened, there was a need for two things, or there was two major changes that has happened in the work environment. The first was there was a need for flexibility. Till then, the laws could be very rigid, protectionism based, where the employer could be held liable for a lot of things, and the court as well as the law were acted as a guardian of the worker predominantly. But as the market opened up, there were more players, liberalization happened. The shift have changed to a more balanced approach, where no longer the law wasn't, I mean, if I could put it this way, the labor law was no longer one sided. They started looking at both the place, and that was the need of the hour. Another change was the rise of contract and informal employment. If you look at a lot of labor law until then, it spoke only about permanent employees, full-time employees. Contract employee, informal employment was hardly discussed. So there was a change in the employment scenario. And to devise the modern day labor law according to changing environment, a second National Commission on Labor was set up. Now, this was established on 15th October 1999 under the chairmanship of Sri Ravindra Verma. and their key terms of reference was to suggest rationalization of existing labor laws in the organized sector and to propose an umbrella legislation for unorganized sector workers who lacked adequate legal protection. So they had majorly two roles. First, there were so many labor laws, 44 central labor laws. If you could just rationalize these things, put a structure to it, sometimes they are overlapping, sometimes they are against each other, sometimes, I mean, very rarely, but yes, some of the definitions are all over the places when it comes to multiple laws. Similarly, if you can bring certain umbrella legislation for the unorganized sector workers who were not brought into the ambit of labor law yet. So the commission studied these aspects in detail and submitted the report to the Prime Minister on 29th June 2022. And as a result, they have given some key recommendations. And the recommendations were first to have labor codes. Now, what they suggested is that, look, boss, there are over 40 central laws that is causing overlap and confusion. So it's best that if you can merge them together into a fewer sets of laws or code so that there is not so much complexity. And often this complexity leads to lack of compliance. People are confused. They want to be compliant, but they're not able to figure out how to do it. So they said, "Ki merge it into labor codes, fewer labor codes." They also said that the current labor laws have an extremely protectionist view when it comes to layoff and contract work. It's high time that we have to have some restrictions. We have to have some easing of restrictions on layoffs and contract work, because that's how the work have changed. The nature of employment has changed. But they also say ki even if you're easing it off, ensure that it is coupled with stronger social security and skill development schemes. It's another recommendation. Now, they also spoke about certain institutional reforms where they recommended a three-tier system for dispute resolutions. It also proposed mechanisms like wage board for timely wage fixation. Another recommendation that they have given was to have certain comprehensive law to extend basic labor rights to workers in agriculture, small enterprises, and self employment who are currently outside the purview of existing laws. Currently, to be within the purview of law, let's say, most of the laws, minimum there has to be 10 workers. And by your personal experience, I'm sure you've known that a lot of workplaces that you have walked into may not be having 10 people altogether. So that's why the commission suggests that we should bring in this unorganized sector also into certain social security schemes. Now, these recommendations came in, and the government decided to work upon it. And there were a lot of changes that has happened post these recommendations. Some of the recommendations, like having labor codes where the central laws are codified, has been completely accepted, and there've been new labor code that is drafted. That is ready to be in practice. Some few what you call bottlenecks remaining. Apart from that, it is out there. So you could conclude that Second National Commission recommendations were were accepted and put into practice in a larger extent. With that note, or let's break the story here at the recommendations of Second National Commission on Labor. We will see how things have changed post the recommendations in detail in upcoming sessions. So just to give you a recap of what we have discussed today, we looked at the entire timeline of labor laws, starting from the Factory Act in the pre-independence era till recommendations of National Commission on Labor. We have seen how you can divide the entire timeline into four categories, which is pre-independence category, where focus was more on British economic interest, and then a post-independence phase where a lot of welfare legislature happened, which was in line with principles of constitution. And we saw that there was a first National Commission on Labor that come in, and they have recommended few aspects, they had recommended few suggestions. And then we saw that post liberalization there was a change in the working condition, and to devise how to handle it, there was a second National Commission on Labor that has been constituted, and we have seen what were the various recommendations given by the second National Commission on Labor. And cut the story short, they proposed having four codes, labor codes, consolidate everything into four labor codes. So the 29 central laws were consolidated into four labor codes. And all that and further we will discuss in upcoming sessions. The next immediate session, we are gonna look at definitions of certain terms, is essentially definition of the term industry and definition of the term employer. So please wait for the next session where we will get into this trickier terms, because understanding its true meaning is very important to interpret it further. Until then, let me take a break. I hope you were able to understand what we were discussing. Looking forward to your attendance in my upcoming sessions also. Thank you so much for your patient listening. Take care. Goodbye.